Hi, good afternoon, and welcome to Digital Transformation Thursdays. We're experiencing some technical difficulties now. Actually, this was the most number of registrants that we received. Over 3,000 people registered for the event. But somehow the attendees in the wait, hold on. I'm getting messages that there are people in the waiting room. Can somebody, hold on. I'm sorry. So we're receiving a lot of messages from people who can't get into the waiting room. Go to that page/live. Okay. If you know anyone who can't get into the Zoom call, for some reason, Zoom isn't letting anyone in, you can direct them to www.dtt.ph, that's our website, /live. And then this will be broadcast there. It's also being broadcast now on Facebook Live at our dcinilaw.ph, dcinilaw Facebook. So facebook.com/dcinilaw. And it's casting there right now, live streaming. Okay, and I see we have about 800 attendees on the live stream. It's unfortunate that until we figure out why participants aren't being able to enter, we will check. This might be a security issue on the settings. I'll figure that out later. Unfortunately, okay. So I guess first things first, I'd like to draw attention to something that's going on. The first thing that you saw was, of course, our upcoming event that we're helping out with. This is Shorts. Shorts is an event where people can come together. And if you want to tell a story for 8 minutes, follow the rule on Shorts, please do so. And you can do that by going to the Shorts webpage. It's www.shorts.ph. When you go there, let me see if I can put that up. Here we go. Let me see if I can share that with you. When you go there, just sign in you can sign in to attend, or you can sign in if you want to share a story. Here it is. This is the website. If you want to share, you can click here and be a short speaker. If you want to attend, you register here. The event is in 2 weeks from now, and the topic is lockdown. All right. Another event I'd like to draw attention to is I'm a member of the Harvard Law Association, Law School Alumni Association, and we are co-sponsoring a talk on mass media in the law, and this is for next week, 3 to 5 p.m. This is with the Philippine Bar Association. As you can see, the speakers are Attorney Panelo and Dean Santa Maria. This is in cooperation with, this is Philippine Bar Association in cooperation with the Harvard Law School Alumni Association and the Lyceum of the Philippines University College of Law. You can sign up at the Facebook page of the Philippine Bar Association. So where you're on Facebook, just look for Philippine Bar Association, and this is a pinned post, so you should be able to see the page, and you and click and register for that event. All right. So we're very pleased to have today as our guest, of course, is Justice Monette Singh, Maria Filomena Singh, who is eminently qualified to talk about the rules on the new rules on evidence. My topic and the title of the event today is the rules on evidence as it relates to electronic evidence. And I'd like to now share my slides. Where are my slides? Okay. Okay, here we go. Okay. So, and I only really have one topic, one question in relation to this topic, right? Hold on, it's paused. Let me resume share. So you can see my slides. Can you see my slides? Why is it paused? Done. Let me just share that again.
Yes, we can see your slide.
Can you see how you saw it? Hold on. Let me restart it. Okay. I guess it was we were overdue.
Rolling.
Yeah. All right. I'm getting PMs from people. Hold on. Yes. Please go to. Hold on. I need to know. I don't know why this happened. Okay, I'm sorry. I'm getting private messages, so let me just respond to them. There's nothing like okay, here we go. Let me resume. Can you see it? Okay. So
yeah.
My talk today is about how the rules on or electronic evidence is treated in the new rules or the revised rules on evidence. Okay. And I basically only have one question to answer now. Are electronic documents governed by the new rules or the revised rules on evidence? And and that might sound like a strange question. Myself, this arises from the fact that certain provisions of the new rules on the revised rules on evidence were inspired from the rules on electronic evidence, which was enacted about 20 years ago in 2001. And prior to this, I think there's always been a clear delineation between the rules on evidence and the rules on electronic evidence. And this was intentional on the part of the Supreme Court when the rules on electronic evidence, actually the subcommittee, we were part of the subcommittee on electronic commerce. Myself, Attorney Francis Lim was there, Lito Averia, Abet de la Cruz. Our chair was Justice Jesus Elvinas of the Court of Appeals. He was our chairman. And one option that we had proposed to the court was the possibility of immediately amending the rules on evidence to allow for electronic evidence. But the Supreme Court felt that time that they wanted to have a standalone set of rules that they will later merge into the rules on evidence. So it's been 20 years and the merger didn't happen. So I was to say the least a bit disappointed that the new rules or the revised rules on evidence did not incorporate the rules on electronic evidence, given that 20 years had passed. So from then until now, there's always been a clear delineation. If it's a paper document that you are or the documentary evidence you are presenting is paper-based, right, not electronic-based, then you use the rules on electronic evidence. And if it is an electronic document, then you use the rules on electronic evidence. So that's the first question, right? If you're faced with documentary evidence, you ask yourself, is this an electronic document? If it is an electronic document, then you go rules on electronic evidence. If it is not an electronic document, then you go rules on evidence. And the authentication modes are different, right? So the authentication modes or the modes of authenticating documentary evidence in the rules on evidence is by anyone who saw the signature, by anyone who knows the signature, and anybody who saw the document signed, anybody who saw the signature. And then there's the additional mode that was incorporated now by showing the genuineness and due execution of the document. In the rules on electronic evidence, if it's an electronic document or electronic evidence document, you have the modes on the rules on evidence. On top of that, you have the modes in the rules on electronic evidence, such as proving the authenticity of a digital signature on the document. And of course, the catch-all is showing sufficiency, through sufficient evidence, the integrity and reliability of the electronic documents to the satisfaction of the judge. And of course, in the old rules of evidence, there was a difference between what was an original in the rules on evidence and what is an original in the rules on electronic evidence. But now, since the duplicate original rule has been adopted, there doesn't appear to be a difference between the two, right? Okay, so just to go back a bit, a short history of the rules on electronic evidence. This was enacted by the court in 2001. Initially, also, one of the concerns of the court was they were concerned that if the court users are not aware or are not fully appraised of how to use electronic evidence in court, somebody might get convicted. And so initially there was an exclusion in the rules on evidence when it was first enacted. And in fact, a lot of the codals out there that show this show that there is an exclusion of criminal cases. And this was true when in 2001, but a year later in 2002, the Supreme Court expanded the coverage of the rules on electronic for criminal cases. Interestingly enough, as late as 2010, a decision was rendered by, I believe, a division of the Supreme Court, where it was held that the rules on electronic evidence do not apply to criminal cases, which was obviously an error. However, that error was corrected in 2014 when the same ponente issued another ruling recognizing that in fact in 2002 electronic evidence was admissible for criminal cases. And as I understood, it was explained to me that the reason why it was overlooked was the manner in which the amendment of the rules on electronic evidence was done in 2002 by the court. Two cases are worthy of note in relation to the rules on electronic evidence. That's the Napocor versus Codilla case and the MCC Industrial versus Sanyong. I'll take the first one, the second one first. No? So in MCC Industrial versus Sanyong, very simple holding. Basically, the court ruled that a fax is not an electronic document. So simple. They said if you're proving a fax transmission, that is a paper document. You cannot rely on the rules on electronic evidence. Therefore, you have to show the original of the document and use the rules on evidence. Of course, I disagree with, and I've said this many times, I disagree with the ruling of the court in MCC Industrial. The court relied on, to support its position, the court relied on an interpellation made by the late Senator Miriam Defensor Santiago of the Senate sponsor of the bill, and that was Senator Magsaysay, June Magsaysay. And Senator Miriam Defensor Santiago asked point blank, so faxes are not included, to which Senator Magsaysay said yes. Interestingly enough, the basis for Senator Miriam's interpellation was her reading of the Canadian Electronic Commerce Act. And in the Canadian Electronic Commerce Act, the definition of an electronic document is different. It did not include transmission by electronic means. But the Philippine law definition in the E-Commerce Act includes transmission by electronic means. So if a paper document is transmitted electronically, then it can be, it is considered it is considered an electronic document. And somehow this definition, the court did not want to apply in relation to faxes. Okay. The second case is Napocor versus Codilla. And in Napocor versus Codilla, the National Power Corporation wanted to present photocopies as evidence, as original evidence. And the argument was that the photocopies are duplicate originals, which are allowed under the rules on electronic evidence. And so the Office of the Solicitor General made the argument that photocopies are electronic documents on the ground that the act of photocopying is an electronic processing of information, and therefore the product of that process is itself an electronic document. And the court could not accept that reasoning. I guess this problem has now been solved by the new rules on evidence, because the rules on duplicate originals under the rules on electronic evidence is now part on the rules on evidence. And therefore, photocopies now are considered duplicate originals under the rules on evidence. Okay, so if you have a photocopy, you can present that, and only under certain circumstances could you be compelled to produce the original. Okay. Okay, so two provisions were, as I say, inspired, or two of the amendments were inspired by the rules on electronic evidence. I use the word inspired because our incorporation in the rules on electronic evidence was actually a copy itself. Now, we copied the provisions from the federal rules on evidence 20 years ago. And it was now that those provisions were carried over to the to the new rules on evidence. And that's a duplicate original rule. And essentially, this is a rule that allows photocopies as original evidence, right? And only in circumstances where it would be inequitable. Well, number one, the first exception is if there is a genuine issue as to the authenticity of the original, then the original must be produced because you're questioning whether the original is in fact authentic. The second is if it would be unfair not to produce the original, and so therefore there's some leeway on the part of the trial court judge to make a determination whether it is unfair not to present the original. Okay, that's a duplicate original rule. The second, of course, is the business records exception, and basically this is an exception to the hearsay rule for business records and for electronic documents before, because this used to be only in the rules on electronic evidence. If you're presenting electronic business records, you don't have to present the person who made the recording. So if the record was made 10 years ago, you don't have to present the custodian 10 years ago. You could present the person who is the actual custodian today. So that rule has now been expanded to cover business records that are paper-based. And just by way of trivia, this rule was proposed by attorney Rolly Vinluan of Accra Law because they were running into this problem time and again. And so the subcommittee back then on electronic commerce adopted it in the rules on electronic evidence. And I think it's a wise rule that makes it easier for companies to litigate. Okay. Now, why is there, sorry, these are the rules that I was referring to, right? Okay, so now I'm going. So I said there's a delineation between the rules on electronic evidence and the rules on evidence. Now there were two things that we inserted in the rules on electronic evidence. I guess you could, I think, my son would call it an Easter egg that tried to bridge the distance between the rules on electronic evidence and the general rules. And the first is this one. This is Section 1, Rule 3 of the rules on electronic evidence, and it says, whenever a rule of evidence refers to the term writing, right, or document, okay, such term shall include an electronic document. So when it says a rule of evidence, technically the rules on electronic evidence is referring back to the rules of court. And actually the reason for this was to include within the scope of the rules on discovery, which I know that's part of rules on civil procedure, but in effect those do have an impact on evidence, and in fact there are exclusionary rules embedded in the rules on discovery. That electronic documents we were hoping could be included within the scope of discovery. Okay, that was the first Easter egg. The second Easter egg is this, which was and now actually considered, you can consider this to be irrelevant or less relevant. This is in the duplicate originals rule, in the rules on electronic evidence. So we said, and I highlight the word document, okay? When a document is one or two more copies. So you will notice if you read the rules of electronic evidence very closely, we always refer to electronic documents. But in this rule, we drop the word electronic. It only says document. And the idea here was that this could technically be interpreted to mean that the rule on the best evidence rule had been amended by the Supreme Court. That in fact document refers to not only electronic document but also ordinary documents. And that argument could have been raised by the OSG in the Napocor case, but I don't think that they did. Nevertheless, it's now irrelevant because this rule has now been incorporated into the rules on evidence. Okay, so the question, as I said, the singular question that is at issue here is, we're trying to figure out, has the relationship, the clear delineation between the rules on evidence and the rules on electronic evidence, is that still good? Or is there some overlap? Now, why is this a relevant question? For a couple of reasons, right? And these are the 4 reasons why. First, in the definition of an original, and this is now on the revised rules, no? An original of a document is the document itself. Okay, so that's an original. But if you look at the last sentence, it says, if data is stored in a computer, then the printout is the original. So therefore, this last sentence here is actually taken from the rules on electronic evidence. And this is the best evidence rule for electronic documents. So if this is best evidence rule for electronic documents, what is it doing on the revised rules on evidence? Unless the intention is to include electronic documents in the definition of original. Okay, so why is it there? Why do these rules on evidence, if they're only supposed to cover paper documents, why does it include this this sentence? It would seem to be surplusage, right? The second one, the second reason why I raised this question is the definition of documentary evidence. And this is on the revised rules on evidence. And I draw your attention to the second part, which is the definition of photographs. It said photographs, because initially photographs were not included in the rules on evidence. Now, photographs actually, you can argue, well, sorry, photographs are not always documentary evidence, okay? But anyway, they added this. Photographs include, of course, still pictures, drawings, stored images, and videos. Okay, so now when you think about stored images and videos, when you say stored images, you don't refer to a paper, you don't refer to a negative, right? Or a print of a picture as a stored image. When you say restored image, you say stored in some media. And therefore, in that sense, that is an electronic document. So now there's a reference in the definition of a photograph that a photograph under the rules on evidence can accommodate electronic photographs, right? And certainly when you say videos, you can argue that a large number of videos, at least in the last 30 or 40 years, are actually electronic. They're stored on magnetic media. And that magnetic media are electronic documents. Now, maybe just as an aside, you may ask, how can a photograph be documentary evidence? Well, a photograph can be documentary evidence if what you're trying to prove is the content of the picture. Okay, so if the picture, for example, or the video shows, for example, the perpetrator stealing the thing or entering a room, right? And you're trying to prove that he entered that room, then the video now and the photograph, or if it's a photograph, are now documentary evidence. And the difference, of course, is that if it's documentary evidence, it must be authenticated before it is admitted. But the purpose, of course, is to prove the facts that are contained in the photograph. Now, you can present a photograph as object evidence. So, for example, you are presenting a witness who was run over by a car. So he's testifying that he was run over by a Toyota Hiace, right? So then you show him a picture. Mr. Witness, here is a photograph of a Toyota Hiace. Is this the kind of car? The car that hit you, did it look like this? If the answer, that question now, the use of that evidence is as object evidence. You're not trying to prove that that is the car that hit him. You're trying to have him identify, for the benefit of the court, what the car looked like via the photograph. So in that case, that object evidence does not have to be authenticated like a document. Okay. The third reason is that in the third reason why I'm asking why if electronic documents are considered part of the new revised rules on evidence is that in the definition of duplicate, it considers a counterpart, that a duplicate is a counterpart that is created by electronic means. So if you create it by electronic means, then theoretically, for example, if I scan a document or I take a photograph of a document with my phone, I have created a counterpart or a duplicate by electronic means. Now, theoretically, that falls within the definition of duplicate under the rules on evidence. If so, then it would seem that an electronic document, or at least an electronic duplicate, right, of a paper document would be admissible now under the rules on evidence. And the question now is, do I authenticate it using the rules on electronic evidence, or do I authenticate it in accordance with the rules on evidence, the revised rules? Okay, so this is another part. The third, of course, relates to the business records exception, okay, which, as you can see, contemplates that the record, right, or the records that are kept are in electronic form. So if the business records are in electronic form, they are now considered exceptions to the hearsay rule under the rules on evidence. Therefore, the question now is, are the rules on electronic evidence, are they, what's the word? Are electronic documents or electronic records, do you authenticate them under the rules on evidence, revised rules on evidence? Because you're relying on section 45 of Rule 130 of the rules on evidence, or are you going to rely on the rules on electronic evidence, in which case you authenticate it using that provision? Okay, so I was thinking about this, and I wish I could tell you that there was an easy answer to this, and I ended up thinking about this in this way, that there are three possible interpretations that you could take with this. The first is that the references in the rules on evidence to electronic documents are drafting errors. That perhaps in the course of transposing definitions from the rules on electronic evidence to the rules on evidence, the words like computer and electronic were ported in. If they wanted to keep a clear delineation, they should have dropped those, so that if the electronic form of that is going to be used, you refer to the rules on electronic evidence. So that's one way of looking at it. It could be a drafting error. The second is to think of it as it was intentional, right? It's intentional on their part, because perhaps, so imagine that you were drafting the rules. Let me see if I can go back to those. If I can go back to those provisions. So imagine you're drafting the rule on the rules on evidence. No? If you're part of the committee, and you've already agreed that photographs, okay, this provision here, that photographs or electronic photographs are part of documentary evidence. So if you concede that they are, okay, then you ask yourself a question. Then how do I prove? Right? What do I do when I need to prove a photograph that is in a stored image or a video? Right? Then it's necessary to have this provision. Right? So it's intentional, they said. So in other words, when this provision talks about data stored in a computer, about what is an original, what you will present, you present the printout, right? Or output readable by sight. So the second interpretation that I'm saying is that it's intentional. That the data, right, stored in a computer, referred to in this section of the rules on evidence, refers to photographs which are stored or in video, or electronic counterparts, or counterparts made electronically under the rules, which is under the duplicate original rule under the rules on evidence, or is an electronic record, right, subject of the exception. So those are the three types of electronic documents contemplated by the rules on evidence. And to fill in that gap, the drafter said, okay, if that's the case, then output readable by sight or a printout is the form in which you will present it. But of course, if you take that position, then the form of authentication will follow the form of authentication in the rules on evidence, and you will no longer present it or authenticate it as an electronic documentary evidence under the rules on electronic evidence. Okay, so that's the third interpretation is that these references are meant to be ignored, and we go back to the old rule where you put the strong delineation between the rules on electronic evidence and the rules on evidence, and that's perfectly acceptable as well. If you were to ask me what I prefer, I actually prefer to have the third one. Let's keep the delineation and let's keep that separate. I think that what we need to maybe moving forward, maybe it's high time for the Supreme Court to put to rest the rules on electronic evidence, and instead what we put in place of the rules on electronic evidence would be the rules on just the rules on evidence, right? And it's a very simple way. It's very simple to incorporate the rules on electronic evidence into the rules. All you have to do, number one, is add the word electronic document in the definition of documentary evidence. We don't even need a separate electronic signature rule. So, and then, of course, expand the rule on secondary evidence to accommodate secondary evidence such as what is mentioned in the rules on electronic evidence as ephemeral electronic communication. And that's my presentation. Since we don't have Zoom right now, we will be constrained to make this presentation. Sorry, we'll be constrained to what's the word? We'll constrained to take your questions via Facebook Live. So I will monitor the Facebook Live part. Okay, so moving on to our next speaker, Justice Maria Filomena Singh, or Justice Monette Singh, who is an Associate Justice of the Court of Appeals. I'm very pleased to have her as a guest. And I'm really sorry for the Zoom issues that we've been having. I'm hoping that people in the people logging in on Facebook are able to log in. I apologize for that, and we hope we'll be able to. What? Okay, let me. Hello, there you go. I'm sorry. There seems to have been no. Okay, so I think we solved it now. We're waiting for the attendees to come in. Okay. All right. Justice Singh, give us a second here. Maybe. I'm sorry. No. Okay. Maybe Justice Singh, you can come. Sorry, let me finish my introduction. So for those joining on Zoom, I just finished my presentation. Now it's so you caught the main attraction, which is actually Justice Singh, and we're very happy to have her. She's an associate justice at the Court of Appeals, a graduate of the Ateneo Law School in 1990. I actually first met Justice Singh when we were both associates at the Castillo Laman Law Office in the early 90s. She has since joined the judiciary, becoming a Metropolitan City Trial Court judge in 2002, and then promoted to the Regional Trial Court, and then to the Court of Appeal. She has an LLM in International Legal Studies from the American University Washington College of Law. She is a briefer and resource person in judicial reform at the Office of the Chief Justice. She won the most outstanding first level court judge of 2007. She is a member of the Corps of Professors of the Philippine Judicial Academy. In fact, in the academic council, in the Corps of Professors of the Philippine Judicial Academy, I believe she's only the single person there who is a member of two committees. Which is actually a testament to her popularity as a trainer and a teacher and as a professional, and the esteem to which she is regarded in the community, in the legal community. She teaches both at the Ateneo Law School and at the UP College of Law. So we'd like to welcome Justice Singh. You can turn on your camera.
Good afternoon. Now. Okay. Hi, JJ.
Hello,
and hello also all who are joining us this afternoon. Digital Transformation Thursday. When JJ first told me about this, of course, I was a bit hesitant kasi digital yung unang word dun sa title. But I'm all in for transformation. So I told JJ I'll try my best, because I'm not really a techie, unlike JJ here. But he told me that I could react to his talk, or I could talk about something else under the new rules on evidence. And I chose to talk about. I told him my choice was to talk about the hearsay rule, because we know that there is a really monumental change or shift in how we are now defining hearsay. So I'm going to talk about that today, and later on, I'll give a little comment also on JJ's presentation earlier regarding the interplay between the rules on electronic evidence and the amendments to the new rules, or the new rules on evidence. Okay, so we'll start with my first slide. So our old hearsay rule was generally confined to the opposite or the obverse of the definition of testimonial qualification. No? Under Rule 130, Section 36, a witness can testify only to those facts which he knows of his personal knowledge. So that was our basic qualification for a witness. Okay, but we did not have in the rules itself. No, we did not have a definition of hearsay. So as it evolved, even in jurisprudence, hearsay was associated with the lack of personal knowledge. Okay, so if you lack personal knowledge, then you cannot testify on it because that will be hearsay. Okay, so that's how it evolved. Okay, let's go to the next slide, please. Okay, so this situation under the old rules developed resulted to a lot of problems for us. First of all, as I said, there was no discrete or concrete definition of hearsay in our rules. Now, although later on, under jurisprudence, Mancol in particular, the Supreme Court developed a definition for hearsay. But instead, what you have in the rules is, as I said, the basic testimonial qualification, and then you have the exceptions, an enumeration of the exceptions of the hearsay rule. The second problem was that, as I also already mentioned, hearsay evolved as a mere opposite of the testimonial qualification. So if you do not have personal knowledge, then you cannot be a witness because what you will be testifying on will be hearsay. Okay? The third problem was that it was inaccurate, no? Because the testimonial qualification that one be limited or that a witness be limited to testimony based only on one's own perception or one's personal knowledge was seen to be not consistent with or inconsistent with the basic purpose for the rules on evidence found in Rule 128, Section 1, which is, it is the means sanctioned by the rules of ascertaining the truth, no, a matter of fact. So if that is the only way to ascertain the truth about a matter of fact that the court has to resolve, why are we excluding it? So it became inconsistent with the basic purpose for the rules on evidence. Okay, and then the fourth problem is that it was isolated in the sense that its application or its application or interpretation was not linked or networked with the other provisions of the rules, specifically Rule 130 on admissibility of evidence. For example, it ignored the application of the opinion rule. No, and later on I'll discuss that further. Now, let's go to the next slide, please. Okay, so here I have the quote from Mancol, which I mentioned, where the Supreme Court in 2017 had a definition of what hearsay is. No, hearsay evidence is evidence not of what the witness knows himself, but of what he has heard from others. And it's not only limited to oral testimony or statements, but likewise applies to written statements. So that is Mancol, the Supreme Court speaking in 2017. No, you can imagine the rules on evidence have been around since the 901 Code of Procedure. No, and only in 2017 we come up with an actual definition of hearsay. All right, and of course in Spinelli, the Supreme Court said that when probative force depends in whole or in part on the competence or credibility of some other person, not the witness, then that becomes hearsay. Okay, let's go to the next slide, please. Okay, so this is just a quote from Spinelli. I'll just leave that for you to read on your own, no, for guidance. Let's go to the next slide. Okay, so now we come to the new concept of hearsay under the 2019 revision of the rules. On the next slide, you'll see that in answer to the problems that I enumerated earlier, the 2019 revision introduced now a concrete definition of hearsay, no? And it also reaffirmed the use of prior out-of-court statements of the witness declarant. It also clarified and calibrated some of the exceptions to the hearsay rule. And lastly, it provided for a residual exception. Can we go to the next slide, please? Paula. Okay, we're done with that. Next slide, please, Paula. Okay, so Next, that one. Okay, so this is the new hearsay rule. No, it's found under Rule 130 still, on the rules on admissibility, under Section 37. Okay, it says that hearsay now is a statement other than the one made by the declarant while testifying at a trial or hearing, offered to prove the truth of the facts asserted therein. Okay, so whereas before, okay, I am the witness, I am testifying in court. If I say something, okay, that is not based on my personal knowledge, that is objected to for being hearsay. Okay, so the problem with that, as I already mentioned earlier, is that we did not define what hearsay really is. Instead, we are just sifting through the testimony on the basis of the testimonial qualification which the rule provides, no? And that is personal knowledge must be the basis for your testimony. And so if you do not have personal knowledge, it will be hearsay. But now, this rule is saying, okay, that hearsay is anything that you say. Can we go back to the preceding slide, please? We're not done with that yet. Hearsay is anything that the witness states outside the present trial or proceeding, okay? All right, so okay, again, had to be very clear. Before, hearsay, the old hearsay rule means the witness lacks personal knowledge, okay? Witness is testifying on the basis of someone else's perceptions, not his own. And that's why it is hearsay. It's not based on his own knowledge, okay? Under the revision, under the 2019 revisions, that is no longer objectionable as hearsay evidence. Now, the ground for objecting to that would be the lack of first-hand knowledge, okay? So the old hearsay rule, okay, has been rebranded or renamed, okay? Now, it is aptly called, more aptly called, the lack of first-hand knowledge rule, all right? Okay, so that is now consistent with the basic testimonial qualification, that for a witness to be qualified, so that's clear. Okay, so that is now called the first-hand knowledge rule. If a witness tries to testify on the basis of what somebody else told him, okay, is that now objectionable for lack of personal knowledge, okay? So I'm talking about now the doctrine of independently relevant statement, okay? If you remember, an old hearsay rule, we had the doctrine which we called the independently relevant statement rule. So what's an independently relevant? Okay, somebody told me that he saw X shoot B. Okay, so somebody told me that he witnessed X shoot B. Okay, and then I'm testifying now as to what that somebody told me. Okay, let's say that somebody is my neighbor. My neighbor told me that he witnessed X shoot B. Okay, so under the doctrine of independently relevant statement, that statement is inadmissible to prove the truth of what was related to me. It is not proof, okay? It is inadmissible as proof of the truth of what my neighbor told me, okay? But it is admissible as proof that the neighbor told me what he witnessed, okay? So that is independently relevant because it is not hearsay, because I'm testifying on what my neighbor told me. That's based on my own personal knowledge, my personal perception, my recollection. Okay, so that is not hearsay. Okay, that's under the old hearsay rule. Okay, now under the new hearsay rule, anything that I, as the witness, states outside of this present proceeding. Okay, so you get that? I'm the witness, I'm testifying in court in a particular case. Anything that I have said previously out of court, out of this case, okay, is hearsay. Okay, so that is now the new definition of hearsay. So under this new definition of hearsay, even it can be verbal or it can be a non-verbal conduct, which could qualify as a statement. No, so a statement is not hearsay if the declarant testifies at the trial or hearing and is subject to cross-examination concerning the statement. Okay, so you know, jurisprudence also, the reason why there is a hearsay rule is because there is no guarantee of trustworthiness. And what is this guarantee? Actually, there are three: that the person be under oath, that the person be subjected to cross-examination, and that the person's demeanor be readily observed by the court. Okay, so those are the three guarantees of trustworthiness. And that is the reason why we exclude, okay, what we used to call as hearsay testimony, because they are not reliant on the actual witnesses' observations or perception, but rather on somebody else's. And that somebody just happens to be out of court. So there is no oath, there is no cross-examination, and there is no observation of the demeanor. And that is the basic reason why we excluded statements like that. No? Now, under the new say rule, a statement that I made, I am the witness, outside of the present proceeding is hearsay. And because of that, it's inadmissible, okay? But the rule provides for 3 instances, okay, when you can use my out-of-court statements. Only 3 instances, okay? And here, the provision states, the first instance is inconsistent, or statements which are inconsistent with the declarant's testimony, I'm the declarant, and given under oath, subject to the penalty of perjury at a trial, hearing, or other proceeding, or in a deposition. That's the first exception, okay? So we will accept, okay, we will accept evidence of statements that the witness, if I'm the witness, my statements that I made, okay, outside of the present proceeding, if they are prior inconsistent statements, okay? So ito yung classic, the first exception is the classic prior inconsistent statement. And we use that for the purpose of impeaching, okay? So that is admissible, okay? Even if it's hearsay, because it was made outside the present proceedings, it will be admitted because it was made under oath, under penalty of perjury at the trial, hearing, or other proceeding, or in a deposition. So prior inconsistent statement, okay? The second exception is a statement which is consistent, okay? So consistent statement naman to, with the declarant's testimony and is offered to rebut an express or implied charge against the declarant of recent fabrication or improper influence or motive, okay? Now, the second one, we're talking about consistent statements, no? The first exception, inconsistent statements, that is very logical and easy to understand because inconsistent siya, we will use it to impeach, so that's okay. But the second one, why are we admitting consistent statements? Hindi ba, won't our records of proceedings be flooded with just corroborative statements? Kasi prior consistent statements, madami yan, di ba? So that is why there is a limitation. Even though it's a prior consistent statement, it is limited by the purpose. And the purpose is, it must be to rebut either an express or implied charge against the declarant of recent fabrication, or example, an express or implied charge of improper influence or motive. So those are the only exceptions, no, for a prior consistent statement. And then the third one is a statement of identification of a person which is made after perceiving him or her. Okay, let's go to the next slide, please, Paula. I'll give you examples, no? Okay. Okay, so the first one, a prior out-of-court statement. Okay, we're done with this. I mean, let's go to the next slide, please, Paula, where I have the examples for them. Okay, the prior inconsistent statement, I already gave you the classic example, like testimony in a prior trial that is under oath and there was cross-examination. So there is, the guarantees of trustworthiness are all present. Okay, so we will admit that. And then the second one, prior consistent statements. Let me give an example. To rebut a recent express charge that the adverse party or the witness is fabricating, okay, or is lying, okay. Let's say that the witness has alleged that his claim is a long-standing claim. Let's say it's a claim from 2 decades ago, 20 years from 20 years ago. And then the adverse party has had a chance to offer evidence, his evidence, and the evidence that he offered was to the effect that the statement on the stand, no, of the witness was a fabrication. That the claim really is just recent, no, not dating 20 years ago. Okay, so on rebuttal, you can present that prior consistent statement. For example, a statement that you made before the authorities, let's say before the barangay, you lodged a complaint, you had it recorded in the blotter, no, and the date shows that it confirms, no, your claim that it is long-standing. It dates back to 2 decades ago. So that one you can present, all right? Okay, as to the third exemption, no, the identification made after perceiving a person. Okay, this is also very, very practical, no, and logical. As you all know, especially the practitioners among us, no, for trials a long time, no, and it's piecemeal at best. Although the rules on continuous trial in criminal cases have really tried to make shorter, more efficient, no. But still, this is the encounter repeated to an offense, no, which happened, let's say in the year 2000. The witness gives an out of court statement, let's say to the police, it can be to another person, no, about the and has it recorded about what he saw, the identity of the, let's say, of the person who attacked the victim. Okay, and that statement was given close to the event, close to the commission of the offense. Let's say in a week's time, the statement was already given. But the witness, because of the delays in litigation, gets to testify only, let's say 5 years after, or 3 years after, even 2 years after, no? And we all know how human memory is really the weakest of all possible sources, right? And so this is the reason why, in terms of providing for exceptions, the identification of what he or she perceived, no, was the identity of another person, is being accepted if the prior statement will tend to establish that, because it has more reliability and trustworthiness because of the closeness in time to the occurrence of the event, rather than the testimony which is happening years later, no? So that prior consistent statement will then be more valuable to the court in the assessment of the evidence. Okay, so that's now our new hearsay rule, no? So I hope that's very clear already. For those of you who came late, I'm going to do a recap, no? Now, what we used to know as the old hearsay rule, which is the lack of personal knowledge, is now more properly called the lack of first-hand knowledge rule. So if a witness is testifying not on the basis of his personal knowledge, then your objection should be objection lack of first-hand knowledge, okay? Now, what is the new hearsay rule? Simply put, what is hearsay? Anything that the witness stated outside of the present proceedings. That's hearsay, okay? So that is generally inadmissible. 3 exceptions. First, prior inconsistent statements for the usual purpose of impeaching. Second, prior statements only for the limited purpose of proving improper motive or to rebut charges of improper motive, influence, or fabrication. And then the third is identification, made immediately after the perception. Okay, so those are the only 3 exceptions when we will get out of court statements of the witness, which is now properly called new hearsay rule. Okay, all right, now let's go to the next slide, please, Paula. Okay, the next slides actually now show you the exceptions to the hearsay rule. They are basically the same, no? Except for some changes in style or to include gender inclusive language. Most of them are untouched, no? Like for example, dying declaration, right? Let's go to the next slide. Okay, this is important. No, statement of decedent or person of unsound mind. No, you are all aware that we have what we call the dead man statute. No? And the dead man statute prohibits testimony about the declarations or statements of a person who is already deceased. No, for the reason that well, the basic tenet of fairness daw should protect the person whose lips have already been permanently by death. Okay, but with the new Section 39, we are now following the international trend. No, we're doing away with that. Now we will accept even statements of a deceased person or a person of sound mind. Okay, before when he was still of sound mind. Okay. Under the following conditions, okay? May be received in evidence if the statement was made upon the personal knowledge of the deceased or person of unsound mind at the time when it was made, no? And the statement, however, will become inadmissible only if it's made under circumstances indicating of trustworthiness. Of course, sa hearsay rule natin, laging ang ating basic criterion is trustworthiness or reliability. Okay? So this is the important change here. There's a dead man statute. No? So we're effectively doing away with that. And then the next slide, please. Declaration against interest. No? Next slide, please, Paula. Okay. We just added, the Supreme Court added the last statement, no? A statement tending to expose the declarant to criminal liability and offered to exculpate the accused is not admissible unless corroborating circumstances clearly indicate its trustworthiness. And this is only very practical because numerous times we receive declarations or statements made, no, by relatives, no, to exonerate or in the hope of contributing to the acquittal of their loved ones. So nawawala yung trustworthiness, di ba? By reason of the relationship. So if there is some indicator like that or some factor like that, no, that's what the last sentence is for, okay? And then next, the actor declaration about pedigree. The important addition here is that now we have included the relationship by adoption, which is only logical, no? Kasi even in jurisprudence, this has already been recognized repeatedly, pero wala dun sa text ng rule natin. So now it's there, no? And even in the subsequent exception on reputation, dinagdag na rin natin yung adoption. The other important part here is here, no? So even if not related by blood or by marriage or adoption, if this person, no, has been so intimately associated with the family or the person, and that becomes the guarantee of the accuracy or reliability of his information on the pedigree of the particular person in subject matter of the controversy, no? So tinatanggap na rin natin yon. This is also already in jurisprudence, no? So kumbaga, we're just institutionalizing what the Supreme Court has already laid down in jurisprudence. Okay, so the next is family reputation. I already mentioned that we added the word adoption already, and then the next is common reputation. The next slide, please. There you go. Here, the Supreme Court thought that it was more important to put priority, no, on local history. So if all else fails, no, wala na lahat ng record. So sabi ng Supreme Court, as far as boundaries are concerned, no, or general history, mas important yung local history or yung local remembrance, no, yung collective recollection ng community na yon. Okay, all right. And then the next one is res gestae, which is not really changed, except that the Supreme Court added the clarificatory phrase under the stress of excitement, which is essentially what res gestae is about. Okay. And then records of regularly conducted business activity under Section 45, no? This has always been a problem before, no? So kasi yung mga memorandum report or compilations, no, made in writing, now dinagdag na rin yung electronic or optical as mentioned by JJ earlier, at or near the time of the transmission, supply of information kept in the regular course of business activity. Okay, if that is the regular practice, no, so that is an exception to the hearsay. So hindi siya hearsay, no, kasi what we used to encounter problems, no, dito sa mga ganitong types ng business records natin, because the court will always look for the custodian or the person who made the entries in the records, no. But we know that most of the time, the ones who made the entries have already left, no? The transition is very quick or very fast, the turnover of personnel. So, ang laging objection doon, objection, no personal knowledge, okay? So, that is why this is an exception to the hearsay rule, no? So, pero ngayon, hindi na yung lack of personal knowledge yan. Kaya na-recraft na yan. That's why it's phrased like this already, okay? All right, let's go to the next slide now. The next exception is entries in official records. There's no real change there except gender inclusive language. And then the last one, I think, the next one is commercial lists and the like, no change there. As well as the next one on learned treatises, except for gender inclusive language again. And then the last one is testimony or deposition at a former proceeding, okay, which we mentioned indirectly earlier on the prior inconsistent statements, no? The only addition here is that before, it only referred to the testimony of someone who is deceased or unable to testify. Here, the Supreme Court clarified, no? Or out of the Philippines, or who cannot with due diligence be found therein, or is unavailable. So dinamihan na, no? The Supreme Court expanded the ground when you can resort to this already, no? So hindi na lang deceased or unable to testify. They've added some clarity here, no? So even if not deceased, or even if not proven to be unable to testify, as long as you cannot find that witness with due diligence, no, or that witness is otherwise unavailable to you, no, so ayan na, you can avail of this particular exception. Okay. Now the last slide refers to a new exception introduced by the amendments. I'm sorry. It refers to residual exceptions. No, so this is a copy, of course, from the FRE, the Federal Rules on Evidence of the U.S. And the Supreme Court thought it was wise to include the residual exception for those instances which we have not thought of at the moment, and which might develop in the coming days, or which might be excluded if we do not have a catch-all provision. Okay, so this is basically catch-all. The only condition is that so that you can avail this is that you must give the other party advance notice that you have this new exception or ground that you are invoking, and so that the other party will have a reasonable opportunity to prepare also to meet this particular claim. Okay, so that is the end of my presentation. I think we will have to go back to JJ for now. Thank you.
Justice. So I think, hold on. Yan yung problema pag, hold on. Okay. So, okay, here we go. Okay, Justice. So I think we're so thank you for that. I'm sorry, I really got distracted by our technical, no, thank you for your patience. I'm happy that the technical issues were resolved in time for your lecture. So they got to hear your views on hearsay evidence. Yeah, so this is really, for me, this is one of the more, I guess, confusing topics when it comes to hearsay. There are a lot of, I think you're seeing I hope you're seeing the chat. They're thanking you, Justice.
Okay, no, not yet.
If only there was yeah, there's I don't know if you see not the Facebook chat, but the chat here on Zoom.
Well, I only see that there are 99 plus messages there, so I'm not opening it yet. Okay.
Okay. If you click it, there's a lot of thank you.
So should I open it? I'm not like you, JP, so I cannot do all these things at the same time.
No, I think I'm the only one who can crash this thing. So you can click on click on that button that says chat. Then you will see the
Okay.
messages, and there's so many messages.
All right.
We have a lot of people from all over the place. There are people all the way from I saw vegan. I saw as far south as Davao. People all
Wow.
over the place.
Okay.
So we're very happy that you're here to join us.
I'm happy to be here, Jay.
Yes. All right. Thank you, Justice. So
Jay,
I
before
think we can. Yes.
Yes, before we move along to the questions, can I just make some comments to your own
Oh yes,
presentation
please,
earlier?
please do, please do.
Diba? About it. Because that is a very very good presentation, no? Kasi JJ, for those of you who were admitted late, I'm so sorry, but you should ask for JJ's presentation, no? Or probably if JJ uploads this is on FB, they can watch the first part, no? Because it's really very important to answer that question, no? The question of JJ was, is an electronic document, no? Now a document within the meaning of the revised rules on evidence, correct, Jay?
Yes, that's my question.
And the ultimate question also is, what do we apply now? When we're talking about an electronic document, are we going to prove it or determine its admissibility, etc., on the basis of the new rules on evidence, or are we still going to use the rules on electronic evidence? Kasi the rules on electronic evidence is pretty complete, di ba? Until pati yung admissibility nandun, diniscuss niya lahat yan eh. So
yes.
So I just want to put in my 2 cents worth, no, dun sa questions ni JJ. First, JJ and I had a preliminary discussion about this. Actually, chat lang kami noon while we were in another meeting. And we were in agreement. Okay, Jay, I think the reason why the Supreme Court did this now, no, na sinama nila yung electronic dun sa definition ng documents is especially because of that promise to you way before when you first crafted the rules on electronic evidence that they will amend the rules, no, to include electronic documents, the definition of documents. So doon naman kasi sa rules on electronic evidence, which was also promulgated by the Supreme Court. So it should be deemed to have revised also, di ba, yung general provisions natin. Nakalagay naman talaga na if there is any reference in the rules on evidence to a document, it should be deemed to include an electronic document. That's expressly provided for in the rules on electronic evidence, as you pointed out, Jay, in your presentation. No? So I believe that an electronic document is a document, no, within the meaning of the rules on evidence natin. And in fact, it is expressly stated there, no, although not in Section 2. Okay, but in Section 4, kasi, as you also showed earlier, Jay, it really refers to those which are stored in a computer, okay, or in a similar device. Okay, so kaya talagang ang intention ng Supreme Court dyan, I was telling JJ in our chat, i-harmonize na yan eh. We cannot have this standalone rules on electronic evidence and then we have these rules on evidence na hindi kasali yon, no? So gusto ng Supreme Court, i-harmonize na yan lahat. Okay. But now, to one question, ang ibig sabihin nun, hindi na natin gagamitin yung rules on electronic evidence or na-supersede na ba yung rules on electronic evidence? Okay. So we all know that under statutory construction, if walang express repeal, di ba? And there is no inconsistency between the two rules, walang ganon, walang implied repeal. So I do not think that the rules on electronic evidence have been superseded. In fact, there are still a lot of provisions in the rules on electronic evidence which will be very, very useful in assessing the admissibility of electronic documents which cannot be found in the new rules. Kasi yung new rules, ang tingin ko lang, this is my personal opinion, gusto lang talaga ng Supreme Court, wala nang nali-leave out. So they included electronic documents doon. Pero hindi masyadong na-flesh out, okay? For some reason, maybe they were in a hurry, I don't know, but hindi masyadong na-flesh out. So I believe that the provisions of the rules on electronic evidence, which are not inconsistent with and can be harmonized with the present amendments, will still be very, very valuable in assessing admissibility and the weight of electronic documents. So that's just my take on your presentation, Jay.
Thank you, Justice. I think I agree with you. Siguro we're in the transition and the court is moving in that direction. So we hope to see that. Okay. I just have I don't teach evidence, but it's really one of my more favorite subjects. What's interesting is that in the first semester, I teach negotiable instruments, which nobody wants to teach. and my students are also taking evidence. So sometimes I quiz them on evidence if I'm bored with negotiable instruments, as any sane person should be. So I like asking them questions, and I like to ask about hearsay because hearsay is not, well, back then was not defined in the rules. So there's all these rules about hearsay, but they didn't say what hearsay was. But I take some the crafting of the provision, I think, was a little confusing if we drill down to the actual words. I wonder if Paula can share with us that particular part, because maybe I can look for that justice. No? Kasi
are we talking about the present? The present rule?
The present.
Okay.
The present rule.
Okay, sige.
The present rule.
Sige, please show
because it says,
that they can see what we're talking about.
Maybe I should I should share my. Okay. Can you do you have that? Do you have it? I can share. I can share my. Hold on. Let me look for it first. Hearsay.
Actually, I have it on my slide also. It's
it's on your slide.
it's on my slide. Maybe Paul locked that.
Oh, si Paul ang bagal. Actually, it was funny.
It's section 37.
Yeah. There were people on the chat. They were complaining about Paula. That's funny.
Oh
okay.
no, please
So,
don't blame her. It's actually my fault because I cannot do my own slides myself.
Yeah. Are they seeing? Are you seeing what I'm seeing? Hearsay. Ito ba yun? Do you see my?
Yeah. Yes.
Okay. 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 So if you look at, if you look at hearsay, ito ba? You're seeing it. I'm making it bigger. Okay. Parang
How come I'm seeing something else?
You're seeing something else? Wait. Maybe
I'm seeing my resume.
Oh, sorry.
I don't know why.
Should be this. There. Okay, there. Right. Okay. So sabi, hearsay is a statement other than the one made by the declarant while testifying at a trial. Okay.
Correct.
Now, if you go to the second, paano ba yun? So, okay. There is I think the crafting is a little could be improved a bit, Justice. Kasi
I don't want to say that kasi.
I will say it then because I'll take this as an academic because
sige.
a little confusing because it seems that there are two people. Okay, it sounds as if you're only talking about one person, which is the declarant and the witness, right? Because it seems that the declarant is the witness.
Yes,
right?
That's true. That's correct.
When in fact, actually, it's easier to understand this, that the declarant is different from the witness. So
no, but that's not the intention.
No, but let me explain.
Okay.
Para kasi I think it's easier to understand it. This is the way I understood it. Also, let me start with the way I understood it when I studied hearsay is this is another formulation. Hearsay is an out-of-court statement submitted as proof of its own assertion. Okay, so number one, if it's a statement made out of court and it is submitted to prove what the statement is saying, of the assertion of that statement. Okay, so yung proof of assertion, submitting the statement as proof of its assertion is in the second part. That's here, diba? Offered to prove the truth of the facts asserted therein. Okay. That means that my favorite example here is you remember the what was that the recorded the Garci tapes. In the Garci tapes, there is a senator. You listen to the Garci tapes. I asked my law students kasi back then to listen to everything and to categorize. Anyway, there's a part there where somebody says, "Hoy Garci, si ano to?" And then he mentions the name of a senator. Okay. So the question was, is that hearsay? And the answer is yes. If you are going to use that part of the recording to prove that it is that senator who is talking, it's hearsay because it's an out-of-court statement, or at least it is used to prove the assertion that the one speaking is that senator. Okay? So that part, that's what I mean by, that is what is meant by when the statement that is being, the hearsay statement is the statement is being used to prove what the statement is saying. Okay, so that
Okay.
part is satisfied. So the second thing about it is, I think you need to the declarant is the one who's making the statement, and then the witness is different from the declarant. I think that's the one, because here's the standard situation of hearsay. Standard situation of hearsay is, sinabi sa akin, so I'm the witness, the declarant is somebody else, sinabi na, oo, umuulan sa barangay namin nung araw na yun. So I will testify on the stand. Sinabi sa akin ni Mrs. X na umuulan daw sa barangay nila nung araw na yun. If that statement is being used to prove that it was raining in the barangay, that's hearsay. The statement, I'm the witness, the declarant is Mrs. X. So that is an out-of-court statement. And the reason why it's hearsay is because Mrs. X is not available to be cross-examined. And so that, sa akin, the way Section 37 is worded kasi, you know, it satisfies my definition. It's just that it's worded in a way that it's a little confusing. It seems as if it's the declarant who is testifying, when in fact it's the other way around. Parang there are two different people. I think that's ano. Yes, yeah. Opo.
Okay, kasi, well, I guess you can say there's an imprecision in the language employed, kasi with the use of the word declarant there, no?
Yes,
when actually what they want to refer to is one person, a witness, correct? No, so
yes.
ang importante lang, the way that you suggested it, JJ, is okay. That to me actually is simple and more straight to the point, no? Pero kailangan tayo mag-provide ng actor para we know from whose perspective we're talking. That's the only thing that I would add to your formulation, no? If we were the ones who formulated this. But we were not. Okay, but we were not. So we have to live with this, okay? And make do with what they gave us.
Right. But I think so. So I think that my definition falls naman within this. But I just want to say that I think you can think about it as, because ang problem dito, okay, so I mean actually it satisfies. The problem kasi made by the declarant, other than the one made by the declarant while testifying. So that says that it's outside the court.
Yes,
diba?
It's out of court. So actually the simple definition now of hearsay is any out of court statement or declaration.
I think yes, I think so. Let me let me make it clear. I think this first sentence does not talk about the witness. It does not mention the witness. So, but ang problem lang kasi,
it does not mention the witness, Jay, but it mentions testifying at the trial or hearing.
Yeah, no, actually, that's the problem. It's said kasi in the negative. It's a statement other than the one made by the declarant while testifying. So, it's an out-of-court statement. That's what it said. They could have said a statement made by the declarant out of court, offered to prove the facts asserted. That would have been clearer, I think.
That's the problem with the rules.
But
the language.
That's what the court means. That's what the court means. The other thing that I wish could have been in the and actually let me just move forward with what I was saying. Yung understanding ko, kasi I think the second paragraph is a little difficult to understand. But okay. But ito yung first. I'll make it easier to understand. Okay, why? If you look at the first part of the second paragraph, a statement is not hearsay if the declarant testifies in a trial and is subject to cross-examination. So that precisely says it all. If the hearsay, the one who made the hearsay statement is subject to cross, then it's not hearsay. So I think that says it all. That first part.
Yes, he's in court testifying. Yes.
Correct. And then the second part naman is well, the other exception kasi is the purpose for presenting. If you're not presenting the evidence to prove the truth asserted, right? Then it's not hearsay. Right? Even if it was made out of court. So yan yung tinatawag nilang independently relevant evidence. Kasi there's a question to us whether independently relevant evidence is still admissible.
Whether it's assertive or non-assertive,
Yes. So for example, you're not trying to prove whether the statement is true, but you're trying to prove that the somebody
statement was
kept
made.
repeating the
Yes.
story. Yes, the statement was made over and over by the same party. So you're not
Yeah.
trying to prove that that what they were saying was true. You're trying to prove that it was said. And so that is within the
Yes.
perception of the witness. So therefore, that's not hearsay. Kasi yung purpose is not going into the statement, the truth of the
Correct.
statement.
That's
That's the
non-assertive.
other one.
Kaya pwede yan,
Right.
yan hearsay.
Yes.
Oo.
I also like the part where the statement can be non-verbal conduct of a person. So
Yes.
that's ang naisip ko kasi niyan is sakali I'm shouting at someone, magulo, and then I say, si ano ba yung gumawa? Tinanong ko. And then the person nods.
Yes.
It's a non-verbal.
That's an example.
Yes, that would be an example where non-verbal conduct.
Also, Jake, if you point to someone, di ba? Like, if
there you
point
go.
to
Right,
someone,
right.
that's the person, di ba?
Sino yung gumawa nun? Tapos tinuro niya. So that's
Yes.
good. That's right. Okay, exactly. I have one more. My other point here is that is this. And this is clear, I think, under U.S. Rules, but it's not clear in the
Yes.
Philippines. That an admission is an exception to the hearsay rule. I don't know if
Okay.
you will agree with me that this is a controversial statement, and I'll try to explain it. Okay,
Go
what
ahead.
is an admission? An admission is an act, declaration or omission of a party.
Of a party, yes.
Of a party. It may be taken against him, right? So this is the
Yes.
rule where this is the rule where everyone points to, where you say self-serving evidence is not admissible, right? Not admissible kasi admission can only
Yes,
be taken
it's-
against you, right?
Yes.
So ang ano ko dito, Justice, is the
Against
word
you.
declaration. The declaration
Mhm.
of a party as to a certain may be used against him. Now, how do I prove a declaration? That means that a witness is going to come into court. He is going to talk about an out-of-court statement to prove what that statement says, right? So in a sense, it's hearsay because it's a statement made outside the court, and it's being used to prove the truth of that statement.
Mhm.
But it is not hearsay because it's an admission. And the reason why it's not hearsay is because it is against a party. I don't know if my mouse can be shown here, but because it's against a party. And a party to a suit kasi is present in court. I don't know if this is a crazy idea of mine. Because he's present in court, he can be cross-examined and he can present evidence to prove or disprove that declaration. But otherwise kasi, if we don't include admission as an exception to the hearsay rule, then a party can use hearsay objection to try to object against evidence of admissions. So yun lang. And anyway, that's the only other thing about hearsay that I thought I think it hasn't really been what's this, turned over much in the law schools. But otherwise, this is a really challenging part of the rules.
Yeah. But I think the change is really is for the better, no?
Yes.
Kasi
Yes.
we now aptly call the lack of first-hand knowledge as the lack of first-hand knowledge rule, no? So hiniwalay na natin siya sa hearsay. I think it's more logical then, no?
Yes. There's a very good question here, Justice Abe. Can the statement of a dead person before this new rule took effect, can it now be admissible because there's now a change? Marang inadmissible under the old rules, but these rules have taken effect. Can they now be admissible?
Yes. Well, kasi, di ba, as I already said, no, the new rule as crafted has effectively done away with what we call the dead man statute, no? So now, even if the declaration was made by somebody who's already deceased at the time of trial, pwede na, no? So, pero yun nga lang, yung guarantees of trustworthiness.
Paano ko yung justice so if it was objected to before, but before the judge could rule.
So you mean it was already offered before, tas dinecline ng court, reject na?
Well, alam mo naman, Justice, normally in court, ang sasabihin ng judge, Sige, let's listen to the testimony. I will rule on admissibility later. That's common.
So,
So,
baka
pero
maraming judges nakikinig sa atin, JJ, ha? Marami tayong kaibigan na judges.
but what is it rolls over, and then now can the judge now say, okay, I didn't rule naman there. Now I'm ruling under the new rules. This is admissible.
But then that would be improper and irregular because objections to testimonial evidence should be made as soon as the offer is made and to questions as soon as the question is made, diba?
Okay. Let's see. Pinaparepeat sa akin yung presentation ko. Okay. Let me see. Ang dami kasing questions. If photocopies are considered originals, will it be correct to say that photocopy demand letter is enough to toll prescription? But maybe we should cross. We're correct. I'm correct in saying that photocopies now, I don't need to produce the original.
Yeah, that's something that we need, JJ, no? Because as I was listening to you earlier, you were saying in parang blanket, no? Any photocopy now is an original, no? Kasi it's made by the process of photography, something like, diba? Correct? Okay. So I do not think, this is again my opinion. I've said this in all my webinars on the new rules on evidence. I do not think that it was the intention of the Supreme Court to make all photocopies originals. That is really, I do not want to use the word absurd, but that is the only thing I can think of. Because imagine, no? Wala nang, kahit anong photocopy, dalhin nyo sa amin sa husgado. And that's the original already. Can you imagine? We are ruling on life, liberty, and property on the basis of just photocopies, Jay, ha? Can you imagine?
Okay. So I will. Ito yung ano kahit. Yeah. The language is the language seems to
yes, oo. Ako rin. Yan din ang basa ko.
Yes.
Pareho tayo ng basa. Tama yung basa na, no? Pero ang thinking ko nga, hindi literal na ganyan ang gusto Supreme Court effect, no? And I know that I know that my view will be validated, no? If cases go up to the Supreme Court on this matter, kasi the Supreme Court would not have, no, intended to make all photocopies originals, no, in that sense, no? Kasi imagine, Jay, photocopy of a title, original na siya, and we will rule the case on the basis of the photocopy, di ba?
Yes. That's why I draw attention to the exceptions. So the first exception is if you're questioning the authenticity of the original, you have to present the original. That's the first exception. That's this. When you're questioning the authenticity of the original, present the original. And the second one, I think, is where the judges can, ito na yung fair play, equity argument. If it is unjust or inequitable to admit the duplicate, then the judge can say, present the original. So ito yung, this is where the judges can still say, I want the original. Because I think it's as you said, Justice, if it's a matter of a person's liberty, parang I'm not going to convict someone on a photocopy. I want to see the original because so this is where the judges have some leeway because there might be some pushback as itong duplicate is admissible as an original. So
actually yung exceptions na yan, ano na yan, parang it's institutionalizing what has already been ruled upon by the Supreme Court in their cases, no, na paulit-ulit, kung hindi ka nag-raise ng objection, winave mo yung objection, no? Yun lagi nila sinasabi about this is the best evidence rule we're talking about, okay? Di ba? Photocopies and originals. So, yan ang repeated ruling dyan. Consistent sila dyan. Hindi ka nag-raise ng objections, ginamit yung ebidensya, sinubmit, you have waived your objection. So I think that's it. But, wag nating i-confuse yung admissibility sa weight, okay? Kasi I'm the judge. I'm the one who's going to rule, okay? Even if it becomes admissible because the other party did not raise an objection on the basis of the best evidence rule, I will not give it 100% weight because as we said, no, it's a photocopy, and the only reason why it became admitted is because the other party did not object to it, right? So meron pa rin namang fallback talaga, Jay, yung mga judges.
Yes.
But I think tama ka doon na siguro ang gusto shinip ng court yung burden kasi gusto siguro ng court maging pro naman kayo, hindi yung lahat ng bagay, di ba? ang kumikilos na lang para sa inyo, 'di ba? Is the court. So be proactive naman to the parties. I guess that's the intention.
That's at the court. Yes. There's a question here. Can you not act on a demand on the ground that it is only a photocopy of the demand letter? I think that I don't know. That's on two levels, no?
So, teka muna, that's addressed to the private individual to whom the demand is addressed, di ba?
Yes,
If you
yes.
can...
Tapos
Okay.
Yes.
All right.
Kasi ako ang sasabihin ko, yes, go ahead.
Kasi ako ang thinking ko dyan, that's still out of court eh. So yung mga rules on evidence natin di pa nag-a-apply dyan, no? So if you receive a demand letter, even if it's computer generated, you act on it, di ba?
Yes. Actually, ang magandang tanong dyan yung fax. If you receive a fax, if I send you a fax, although ngayon wala na nagpa-fax, if I send you a fax, what's the original? The one that I sent or the one that you received? That's diba? Kasi that's similar to this. Pwede sabihin, ay, hindi ko naman natanggap yung original eh. Ang natanggap ko yung fax. That's not the original. I'm not gonna act on it.
Correct.
I think that's their question.
And of course, papasok din yun yung decisions ng Supreme Court saying that facsimiles are not electronic.
Not electronic,
evidence,
yes.
Diba?
Pero ang view ko dyan, Justice, is that
pasok din yun.
Ang view ko dyan, Justice, is that the fax itself is an original. It is an original of what you receive. It may not have been, it's not an original of what was sent, but certainly it's an original of what was received. In fact, it has the timestamp on top. So
correct. Remember, Jay, during our chat, ang sabi ko sa'yo, pagka ang issue is best evidence rule, we're not talking about the original the evidence, the first ever of document, diba? Kasi a document could have many copies, may carbon, tas meron yung original, tas nagkaroon na rin siya ng photo, 'di ba? So which is also deemed as an original, 'di ba? So ang pagka pinag-uusapan natin na best evidence rule, please remember, it is the copy that you are questioning. That is the subject matter of the litigation. Yun. So kung doon sa example ni JJ, kung yung facsimile na ni-receive niya, yun ang document at issue. Aba, original na pinag-uusapan natin.
Yes. Okay. If I write on an iPad, is it admissible? Is it admissible in evidence in court? Well, if you can get the iPad document, I guess, no?
Or if you have a printout, diba? Of what you wrote on the iPad, that is a duplicate, diba? The printout is a duplicate.
That's right. Ito, Justice, hindi ko lamang sagot ito. May I ask whether Benedict Victa asks, may I ask whether the new rules on evidence are applicable during defendant's presentation of the case, where the plaintiff's presentation was governed by the old rules?
Okay.
Tapos how about when the case has not yet reached pre-trial? Do we apply the new rules?
Okay. So for all those who are listening, meron pong clause on effectivity which was placed after the new rules on civil procedure, no? But I believe that it is also the clause of effectivity for the new rules on evidence, no? So ang nakalagay po doon, it applies to all pending cases, okay? Those which are not yet submitted for decision, okay? Pero may qualification unless it will result to prejudice to any of the parties, okay? So pwede kayong mag-move sa inyong court where your case is pending to the effect na it will cause prejudice to you because there's an equal treatment, because the first party, etc., the evidence of the first party was appreciated under the old rules, etc. Pero alam nyo po, ganito yan eh. Kung hindi naman affected yung presentation of evidence nyo nung new rules, or kung yung evidence already presented, which was admitted on the basis of the old rules, would not have changed despite the revisions in the rules, wala naman pong prejudice siguro doon sa inyo, no? So but like I said, you can go to the judge and file a motion because there's a condition in the clause on effectivity.
There's also another question, Justice. This was emailed to us. The question is this. Let me see if I can. So sabi nila, there is already the rule on duplicates. I think I'm showing it. So there's already the rule on duplicate, sabi nila. And the duplicate is a counterpart. And the duplicate supposedly is the same, the original. So sabi nila, if that's the case, then why is there a rule now on secondary evidence? Which I thought was an interesting question.
Okay. Okay. No, I'll go back to our earlier discussion, our exchange already, Jay, no, na ang tingin ko dyan, nung ginamit po ng Supreme Court yung word na photograph, included dun sa documents, perhaps hindi nakita yung repercussion na ngayon yung mga photocopies, they are made through photograph, through a methodology, di ba, na ganon, photography. So, I think yun, no? I'm sorry if I have to say it like this, but I know in my heart, no, na hindi intention ng Supreme Court to make all photocopies originals. Although JJ and I discussed nga kanina yung unless, no, yung dalawang exception, no. So it would seem to shift the burden. Parang binago natin ngayon yung burden of proof. Parang iniba natin yung burden of proof pag ganun ang ginawa natin. So that's really something that the Supreme Court has to clarify, and in the days, hopefully our position will be validated.
Yes. Actually, Judge, I was thinking baka naman the way to harmonize is tinutulak ko lang yung interpretation ko. So, ang interpretation ko is admissible ang photocopy
unless objected to.
But if unless objected to and the judge feels that it's in which case you have to present the original. But if you cannot present the original and you lay the predicate, then you can rely on secondary evidence where the photocopy now is considered the original because you laid the predicate. Wala kang choice eh. Lost.
Oo. Yeah, so we go back old pa rin. Yung
we can go back.
Yes. Yeah.
Yes. I think na-confused lang sila na parang kung pareho. Oo. Pero kasi I think so I think there's a mindset that needs to shift. I don't know if how the Supreme Court or how the
hayaan mo, oo nga, oo, sige. No, kasi
committee will...
By the way, sige, since there are a lot of people listening, the Supreme Court is coming, is going to have a launch of the new rules, no? Both of the new rules on evidence and the new rules on civil procedure on August 20, okay? And you can watch it sa YouTube channel daw ng Supreme Court. I didn't know the SC has a YouTube channel, but anyway, meron daw. No, and I'll give you the link, Jay, so you can also circulate it.
We will distribute that to everyone. Yes.
Maganda to kasi doon, no? There will be a video highlighting the changes, tas may primer din. So it's like it's like an info launch, okay? So you may also into that, and then yung questions nyo also pwede nyo directly ipadala doon through the Supreme Court PIO, the Public Information Office, para masagot din, no, ng proper authorities, no. That's the one.
That's the one. So the launch will be on August 20, 2020 at 10 a.m.
Yes.
Hindi naman kasi at 20 hours. Yes. Kasi alas 8 ng gabi nun. So,
no.
ginawa nilang 10-10. Para 20 pa rin. May numerology at ang pinapasok sa timing nila.
Ay, feng shui ba yan?
May feng shui. 10-10 magsa-start to yan. Hindi 10 o'clock magsa-start. So that's good.
Jay, Jay, can I answer one question here? The one that you sent me through email. Kasi this is important, no? It has to do with printouts of web pages of foreign government agencies. Nakita mo yan, yung number 2 doon sa in-email mo sa akin. No? It says, do printouts of web pages of foreign government websites need to be authenticated? No? If so, what are the requirements? Okay? And would a certification from a qualified person describing the process by which the web page was retrieved already suffice? And then does the qualified person have to be from the same government agency? This is the owner of the website. Now, I want to discuss this. And I think the reason why this was asked is in relation to foreign divorces. No? Kasi marami tayong umaakyat hanggang Supreme Court ng mga recognition of foreign divorce. And most of them are divorced by agreement from Japan, okay? So, ang dami ng issue dyan na interrelated, no? But I will take up the issue that was raised, no, in relation to printouts of web pages of the foreign governments. Yun na nga, for example, in Japan. Kasi, you know that in recognition of foreign divorce, there are two things that you need to establish if you're the petitioner. You need to establish the foreign divorce, of course, as a fact, no? And then the second, you establish that through the foreign judgment, okay? Or the divorce decree, that's the first one. And then the second one is you need to establish the foreign law, okay? Yung law nila, divorce, no? Or giving it validity, okay? You need to prove that. And how do you prove it? The way to prove that is by going to Rule 132, no? Sa atin, Section 24. And that is either by an official publication, okay? Or a copy, which is certified or attested by the custodian, the official custodian, okay? And this must be accompanied by an attested certificate of our consular official. Yan yung ginagawa natin dati, di ba? Yung pupunta ka sa consulate, kukuha ka ng authentication there by our consul, etc. And then may red ribbon, which of course that now has been replaced by the apostille certificate, okay? So ngayon, para mo i-prove yon, yung proof of official record, including foreign documents, no, foreign official records, like for example, the foreign law, no, of Japan, kukuha ka ng official publication. Okay, so yung official publication will necessarily be Japanese, okay? Kasi foreign language, okay? Now you also need an official translation into English, okay? So dalawa, okay? And then if you cannot have an official publication, then you can have a copy of it, which is certified true and correct by the official custodian, okay? Plus the official translation, plus the authentication from our consular officials, which is now replaced by the apostille certificate which you get from the DFA, okay? So ngayon, gusto ko kayo i-advise, no, medyo step-by-step increments tayo dito. Kasi naguguluhan tayo by reason of the fact na, yun nga, for example, in Japan, they allow divorce by agreement. So they do not go to the judge. They do not go to the court at all. No? So it's just an agreement. Somebody has to consent. And then it's the mayor, sometimes it's the mayor who just issues a report of the divorce. No? So walang judicial decree. So that alone is an issue already. But that's not the issue that was raised in the question. So I want to tell you in relation to that particular question, the latest ruling of the Supreme Court is Takahashi, no, versus Morana. That's a December 5, 2019 decision of the court, no, which was penned by Justice Javier, no, Ami Lazaro Javier, no. At doon, ang present nila na proof nung Japanese law was a mere printout, okay? Printout lang from the website, okay? Nung I don't know, I think it was the Japanese embassy website, no? So they just printed out from that website, tapos they gave also the counterpart English translation also from the website, okay? And the Supreme Court did not accept that, okay? But because involved dito yung Filipino spouse na nagka-divorce na yung, you know, na-divorce na yung na-divorce na effectively under Japanese law yung foreign spouse niya, di ba? So Republic versus Manalo na tayo. We don't want the Filipino spouse to remain tied to the foreign spouse when the foreign spouse is already free to remarry. So kaya ginawa ng court dito, instead of dismissing the petition, kasi nga mali, wala silang proof of the foreign law because they just printed the website or the law from the website, what the Supreme Court did is to remand the trial court to receive proof of the foreign law. So kumbaga, binibigyan ng Supreme Court ng isa pang chance yung Filipina, okay, to prove the foreign law. Although, may misgivings ako dyan, ha? Kasi marami kaming cases sa CA na ganyan. Nag-aaway, hindi kami nag-aaway, but may mga dissenting opinions kami. Kasi I, for one, I do not want to remand it, no? Because ang katuwiran ko dyan, teka muna, natapos na ang trial, both of them had their chance, tapos decided on the merits, so why will you reopen the trial now when that was never sought from us, diba? The party never asked us to reopen, the party never said, oh, wait a minute, I hate coming evidence, wala, no? But on our own, we will give that party another chance. Well, of course, the reasoning of the is the kawawa naman, no? And well, I understand the equity side of it, but procedural. I'm speaking from a procedural standpoint, ha? Kasi remedial law teacher ako, no? So kaya ang position ko is not to remand. But But before I leave this topic, no, I just want to inform also the others, no, about the other cases decided by the Supreme Court na involving itong mga proof of foreign law. Dun sa case na Rado versus Tanaka, June 2018, this was penned by Justice Marvick Leonen, no. Ito, ang present nila is not the original of the Japanese law, meaning it's not Japanese anymore. What they presented was an English translation of the Japanese law, but the translation was made by the Ministry of Justice and by the Code of Translation Committee of Japan. Okay? Kaya sabi ni Justice Leonen, official na yon, no? Even if we do not see a copy or the official publication of the Japanese law in the original language, okay? Okay na daw yon. So tinanggap niya yon in Racho versus Tanaka. Okay? Now, in the case of Sakai versus Republic, this is July 2018 naman, no? 1 month after Racho
they're all
versus
Japanese,
Tanaka. Oo, they're all Japanese. Kaya nga sabi ko, I'm sure yung nagtanong niyan, yan ang case niya. May Japanese foreign divorce decree siya, no? So here, photocopy lang. Ito ha, photocopy lang ang present nung Japanese law. Okay? Definitely, hindi tinanggap ng Supreme Court. Remanded for reception of further evidence, no? And then the last one is Areza versus, this is July 2019, no? Recent lang, a year ago. No, a copy of the Japanese law in Japanese, no? So copy ron, pero yung English translation niya was by a private translator, hindi official, no? So hindi rin tinanggap ng Supreme Court. Sabi ng Supreme Court, hindi self-authenticating tong document na to. This is a private document, so, and it was not proven. So ni-remand din ng court yan for further evidence. So just to give you a survey, no, how the Supreme Court is ruling on the proof of foreign law in foreign divorce judgments. Okay?
So thank you, Justice. That's very helpful. So okay, yeah, very tricky ang foreign law.
Yeah.
And maybe somebody should write a definitive article on how to go about that, because it's in many. So that's interesting you said about an agreement of the parties to divorce. So it's not even a decree. It's just a document that's in a public record.
Correct. Pero in the case that I cited to you, in Takahashi, sinabi ng Supreme Court through Justice Javier na eto nga, precisely because divorce by agreement is recognized under the Japanese law, no? And wala talagang divorce decree because they never go to court, no? So sinabi na dun sa Takahashi, the divorce or the report on divorce and then the certificate, no, that they issue after there is consent already or acceptance, that takes the place now of the divorce decree. That was already clearly stated by the Supreme Court in Takahashi.
But that's interesting. Then you would just need to prove that the law allows it. So
yeah,
parang
kaya
divorce.
Kaya proof of the Japanese law is required.
Okay. This is an interesting question coming from actually a classmate of mine who's a bank lawyer. He says, can the parties stipulate in a contract that the photocopy will be considered as best evidence of the agreement? An interesting question.
I don't think so, because it's the reason why we have rules of admissibility, diba? The rules must be followed. They are not subject to the party's will.
That's interesting. Okay.
Ang gawin mo na lang, huwag ka na lang mag-object. Hayaan mo i-present kay photocopy to not object, diba? Because it will have the same effect under the present rule as worded, diba?
Yes. Actually, there's an old Supreme Court case, part of my one of the cases that's cited in the Campos book on negotiable instruments, where there was a provision in a loan agreement or a promissory note that said that, okay, if you default, you allow the lender to appoint a lawyer for you in court, so that when we bring the case, your lawyer paid for by the lender, right, will appear and will admit judgment. Give up agad para may judgment na. So sabi ng Supreme Court, you can't deny a party in court. That's that's waiver of future fraud, which is void.
That's true.
Admission. So that, I think that in that vein kasi dun papasok yun. Can you agree that this is admissible and that is not admissible? But I'm sympathetic to what my classmate is asking, because if you're a bank, and especially if you're sakali online lender, you have all these transactions. Kung himay-himayin mo lahat ng evidence mo, pwede ba mag-agree na lang tayo? Ito na yung best evidence para when we go to court, ito na yung agreement natin. But you're right, Justice. Ang problem naman ng court is, can the court agree? I mean, maybe in pre-trial they can agree, right? If in pre-trial they agree, okay, that's the evidence.
Yeah, they stipulate na, di ba? Present a photocopy. Are you ready to stipulate that this is a genuine reproduction, di ba? Okay naman yun. We always do that at pre-trial. Jay, there's one more question here.
Yes, Justice. Yes, please.
Yung sa pinadala mo that I want to answer, no? Sabi dito, the rules on electronic evidence provide that its scope covers all types of cases, no? Civil, criminal, quasi-judicial, and administrative proceedings, no? Of course, this was only settled after Rustan Ang. Rustan Ang was the case you were referring to earlier, yung sa criminal, di ba? Rustan Ang, it was settled in Enojas, no, in 2014, na pati criminal pwede na. Pero ang question niya kasi dito, would this mean that a person may validly invoke the REE in non-governmental and non-judicial venues such as administrative investigations in private companies, workplaces, or schools? My answer is yes. Diba? In administrative cases, matagal na yan, no? The case of Vidalion Magtolis versus Salud, correct? That was an administrative investigation in the Office of the Court Administrator, where text messages, no, in the phone were used, no? So matagal na po nating inaalaw yan, no? But dun sa private, no, it depends on the it depends really on the rules, no? Dun sa system of discipline or mediation, or how do you call that, dun sa private company or dun sa school, no? If it will be allowed. And of course, we also remember dapat na in administrative cases, the technical rules on evidence are not strictly applied, no? So kailangan natin alalahanin din yon, no? So if that's the only thing you're counting on to bar the presentation of that particular evidence, you might not win sa administrative or outside the judicial process.
That's right, Justice. I agree with that. What's interesting, I think, I don't know if this has been examined closely, was in the case of St. Teresa's, that famous case on habeas data.
Yes.
That was technically a private matter. And then the court was basically saying between two individuals where the state is not involved, somehow you're entitled to assert the right of writ of habeas data. I thought that was fascinating kasi arguably it's government against individual. Then the writ can issue. But now the writ can issue between private, because that's the school versus ano. So I thought that was
right.
And
the students.
no one's really pushed that forward. Kasi in those circumstances, then if you can issue a writ against an individual in that situation, then can you say if you can bring in these writs into a school setting, then this is a fair question. The question that's being asked is, well, if this is going to end up in court anyway, baka it might be more prudent for a school to apply the rules and evidence. But I agree with you. I think I don't think it should necessarily apply. I think what's important is, and I think it was expressed in that case in UP where UP was involved. It went all the way up to the Supreme Court, where the Supreme Court said that what you're entitled to basically is due process in general. And and due process doesn't necessarily mean, and even in admin cases, Justice, I think strict rules, application of the rules and evidence are dispensed with.
Yes.
Yes.
No,
Okay,
hindi ano. The last JJ, kasi may last question siya, the same person. Sabi niya, is the rules on court under the authority of the Electoral Commerce Act? Would this mean that the rules on electronic evidence have the force and effect of law? I want to say that all rules, remedial rules, or rules of practice, procedure by the Supreme Court have the force and effect of law, no? Because it's issued pursuant their rulemaking power under the Constitution. Of course, subject to complying and paying heed to the dictates of the Constitution and substantive law. But yes, the remedial rules issued by the Supreme Court have the force and effect of law.
Yeah,
that's the last question.
Well, yes. Actually, so the way that it happened was the Electronic Commerce Act declared that electronic evidence was admissible, and then passed on to the Supreme Court the authority to pass the rules. And so So yes, it started, I guess, in this particular case, it started a statute, and then the rules came from that. So another example of that is was something recently, the ganun rin where, for example, although the
Cybercrime?
court hasn't done it yet. Yes, exactly right. Cybercrime.
Cybercrime.
Cybercrime, where the issuance or the kinds of warrants, and you were part of that drafting committee, di ba, Justice?
No,
The rules,
I wasn't.
di ba? Sorry. Resource
That was
person.
Justice Rona.
TWC.
Si Justice Rona yan.
Justice Rona, our guest
Yeah.
last week. So yun naman, the Cybercrime Prevention Act created certain investigative authority on the part of courts and the part of law enforcement agencies, and the Supreme Court implemented them through the rules on cybercrime warrants.
Yeah.
But it's interesting, this rulemaking power of the court. You know, if I'm not mistaken, the federal rules on evidence in the federal is actually a statute. It is a law enacted by the U.S. Congress. So in the U.S., rules of procedure may be passed upon by Congress and enacted as a statute. In the Philippines, I think if Congress ever attempted to write a rules of procedure, I think they will get slapped down by the Supreme Court. And I think this was expressed in a case I read only recently about the Legal Education Board, where basically the court said this is our domain, and what we say is law. So
yes. At saka, what is that case on the Bar Flunkers Act, JJ, di ba? The Congress enacted a law which was fixing the rate of passing, di ba? So, syempre, sabi ng Supreme Court, wait a minute, that's Section 5, that is our sole domain.
Correct, Justice. Okay, Justice. We're actually out of time, but the discussion has been very, very engaging, and I really appreciate that you took the time to answer the questions that were emailed and really put in some. Thank you, Justice.
That was our
would you like to
promise
have?
to them.
Thank you, Justice.
Would you like to? Jay?
Yes, Justice.
What we can do, Jay, is for those questions we were not able to answer now, you can send them to me, and then I will answer them, and then I'll email you my answers. So that
that's very generous of you.
To them.
Okay.
We can do that.
Would you like to have some closing statement, Justice?
Okay. To all the practitioners out there, to all our judges out there, no, my pakiusap is this, no, the new rules on evidence, the new rules on civil procedure, they are all intended to help make litigation more efficient and more effective for all of us. Okay, not just for the judges to decide their cases faster, but for all also clients, no? So can we just give it a try, a really good try, and then if it doesn't really work, we can tweak it later on. But before we have tried it, let's not criticize it yet. Okay, so let's try it first, no? And for all the law students naman there out there listening to us, especially the reviewees, we are wishing you good luck. No, the reason why I participate in webinars is because especially in this time, no, of the pandemic, you are really parang disadvantaged because you do not have the usual resources that you have for review. So this is our way of trying to help you, clarifying the issues. If you have more issues, more questions, then get in touch with us. You can get in touch with me through my email, and we will try to help you so that you can hurdle the bar examinations despite the circumstances. Thank you, Jay, for inviting me. I hope this wouldn't be the last time.
Hi, Justice. Grabe yung demand. I'm seeing, there's more than 1,000 people right now, and they've stayed all this time. So it's a very
thank you to all of you.
Yes, Justice, you're very generous.
Congratulations for putting this up, huh?
Thank you, Justice. Thank you. We're very happy that we're able to. This kind of discussion happens usually when we're in PhilJA, and it's so nice and refreshing that we can share to a larger audience, and that there's appreciation, a lot of appreciation coming from our attendees, Justice. So thank you. So on that note, I'd like to thank you for attending our. I think this is our 8th Digital Transformation Thursday. Next week. Oh my God, I forgot my topic for next week. But no, next week is data privacy with Don Di Mapa. And Don Di Mapa, we should listen to him because he was one of the first. He was one of the first deputy commissioners of the National Privacy Commission. He is now the regional data privacy officer of Citibank. And if you are interested in data privacy and how to run data privacy across different borders, Asia Pacific in this particular, you may want to join in next week. And Dondi doesn't just talk about the legal aspect, he will talk about managing data privacy. He talks about the information security side. Because he's not a lawyer, he's able to see it from a different perspective. And I think it will be a very engaging session. So I hope you can join us for that.